Welcome to Legal AF. I'm Mike Sachs, a senior advisor with Court Accountability Action, and I'm here to talk to you about a Supreme Court oral argument that just happened that might threaten the future of the Voting Rights Act, or at least what the Roberts Court has let survive so far over the last dozen or so years. Now, it's a case that is arising out of Louisiana over a fight over the state's redistricting maps. Now, it's kind of a convoluted history, but ultimately what it comes down to is that Louisiana created new maps to comply with a court order that said its previous maps violated the Voting Rights Act for being racist, for not having, for disempowering Black people in the state. So Louisiana came back, and they made new maps, and then they were sued by non-Black voters. That's how they called themselves in the litigation, to say that those maps violated the Equal Protection Clause's guarantee that no race shall be treated differently. So there's a clash between the Voting Rights Act and its landmark securing of voting rights and voting power and equal voting power for Black people in this country. That was in 1965. And the Equal Protection Clause, which also was ratified in 1868 from the 14th Amendment out of Reconstruction to ensure equality for Black people in this country. But because its language is race neutral, it's also used to combat race-conscious remedies that come out of the Voting Rights Act to ensure racial equality in voting in this country. So we have this situation right now where the efforts to enforce the Voting Rights Act, which must take race into account, so to make sure that Black people and brown people and non-white people in this country have voting power in proportion, at least in proportion, at the very least, rather, in proportion to their numbers in their districts and in their states. That conflict between that and the conflict between the Equal Protection Clause's guarantee of, well, equal protection under laws. That's no state shall discriminate on the basis of race. And this is the issue in Louisiana. This is the case that's coming to the Supreme Court right now. They're now taking it under advisement because they heard an oral argument yesterday. And the good news is that the court did not seem perhaps to have the appetite to have this unhappy day, this clash between the Voting Rights Act and the Equal Protection Clause come together. Now, of course, the people who think it's a clash are the 6 of the Republican appointees in the supermajority in the Supreme Court. The 3 Democratic appointees don't think there's any clash, and they think those two things, the Equal Protection Clause and the Voting Rights Act, are perfectly consistent. But a couple years ago, literally a couple years ago, in a similar case out of Louisiana, the Supreme Court came very close, one vote shy of not just throwing out remedial maps in Alabama to comply with the Voting Rights Act, but also to say that, well, the Voting Rights Act, Section 2, which is what remains, I can get into what doesn't remain, Section 2 of the Voting Rights Act violates the Equal Protection Clause. That's a big deal. That's a huge assault on voting rights in this country. And there were 4 votes for that. Justices Thomas, Alito, Gorsuch, and Barrett. But there was also 1 vote for it that wasn't ready to vote for it then. And that was Justice Brett Kavanaugh. So inexplicably, because Chief Justice Roberts had never voted for a voting rights plaintiff, I don't think ever, during his time on the Supreme Court. He'd been the lead flag carrier, leading the charge, developing a voting rights restrictive anti-democratic jurisprudence since he started on the Supreme Court in the mid-aughts. It was the first time Chief Justice Roberts said, oh, no, cool, I'm going to side with the voting rights plaintiffs here. And it was a huge shock. And he brought along Justice Brett Kavanaugh to join the 3 Democratic appointees, Justices Sotomayor, Justice Elena Kagan, and Justice Ketanji Brown Jackson. But in a concurrence in that opinion, in that decision, it was called Allen v. Milligan, there was Brett Kavanaugh in concurrence. And in that concurrence, he writes, and he quotes Justice Thomas in his dissent in that as well, that even if Congress in 1982, because we're dealing with amendments to the Voting Rights Act in 1982, could constitutionally authorize race-based redistricting under Section 2, that's Section 2 of the Voting Rights Act, for some period of time, the authority to conduct race-based redistricting cannot extend indefinitely into the future. But Alabama did not raise that temporal argument in this court, and I therefore would not consider it at this time. This is what I like to call Kavanaugh's loaded gun. He loaded up this gun, put the bullet in the barrel, on the revolver and placed it down there for some litigant to pick up and say, but now it's gone on too long. It's been too long since 1982. And now there is some implicit sunset provision on one of the most important provisions of the Voting Rights Act. And it's now unconstitutional. And now states can just racially gerrymander black and brown folk out of political power to their heart's will because to fix it otherwise would be to take race into account and therefore be unconstitutional. All right. So Kavanaugh put that gun down. Alabama tried to pick it up like a few months later after that decision came down, and the Supreme Court wasn't interested. But since then, several other litigants, states have picked up that loaded gun against the Voting Rights Act. And in the case, in the oral arguments yesterday at the Supreme Court, Kavanaugh picked up the gun. I want you to listen to this clip right here.
One of the arguments that the appellees raise is that there's a durational limit on the authority of Section 2 to force states to create additional majority-minority districts. I think that's pages 36 to 38 of the appellee's brief.
So Kavanaugh himself says one of the arguments that the appellee raises is that there's a durational limit on the authority of Section 2. Well, to create majority-minority districts. No, they were repeating back at him what he wanted to hear. So this was a dangerous moment. He's picked up the gun and he's showing he is ready to fire it. But as the argument went on, it seemed it wasn't quite yet ready because this case didn't come up with the litigants specifically saying, pick up the gun and kill the Voting Rights Act, Section 2. No. That's a separate case in this Louisiana litigation that isn't before the court. But the court is aware that there's another case coming up from Georgia that the 11th Circuit just heard that in which Georgia did pick up the gun to defend its racial gerrymanders. It's maps that violate Voting Rights Act. And that's only a matter of time, perhaps even next year, till the Supreme Court hears that. And there may be very well 6 votes to kill what's left of the Voting Rights Act. Now, I say what's left because let's end with this. Do you guys remember in 2013, there's a case called Shelby County versus Holder? That was a case about a challenge to the Section 5 of the Voting Rights Act. Now, this was the most important piece of the Voting Rights Act because it was what was called a pre-clearance provision in which any area, state, municipality, town that was covered under the Voting Rights Act based on a history of voter discrimination had to go to the Department of Justice and get pre-clearance for any change they make in their election laws, if they want to change a polling booth, what have you. And for as long as the Voting Rights Act was established since 1968, there were largely southern states, but there were some other northern areas also that were covered by it. They would go to the Supreme Court, they would go to court and say, this is unconstitutional. And the Supreme Court over and over again ratified the constitutionality of the Voting Rights Act, Section 5, the pre-clearance provision, until 2013. Then in a 5-4 decision authored by Chief Justice John Roberts, the Supreme Court struck down as unconstitutional the formula used to get the pre-clearance in action, to execute the pre-clearance provision. The formula that Congress had passed in the reauthorization of the Voting Rights Act in the early 2000s said that you can use this sort of formula to figure out whether there's been a history of discrimination, whether that still exists, whether it's still vital. A lot of congressional research, congressional hearings, thousands upon thousands of pages were taken to justify re-upping this formula to ensure that covered jurisdictions were still covered by the Voting Rights Act. And John Roberts said, nope, sorry, the whatever Congress did doesn't matter to us. It's been long enough. Things have changed in the South. And by a 5-4 vote, they invalidated the pre-clearance provision, so rendering the pre-clearance itself in Section 5 nugatory, a nullity. And like the day after, a bunch of states that were previously covered by the Voting Rights Act started passing strict voter suppression laws. Surprise, surprise. But in Shelby County, Chief Justice Roberts said, but there will always be Section 2, which allows litigants who feel like they're going to be discriminated against or want to object to laws that have already been passed in the states to restrict voting rights. People can sue once they've already been injured. They can't wait. They can't get out of it ahead of time with pre-clearance. They have to wait till they're injured. And that's what Section 2 is for. But that wasn't enough for people who want to restrict voting rights. No. Instead, the states that want to keep restricting voting rights, that want to keep with their racial gerrymanders and call it political, they want to keep diluting the political power of Black people in their states, they're out to kill the rest of what's left of the Voting Rights Act of 1965, and it's as amended in 1982. And that is what Kavanaugh's gun is for. He picked it up yesterday, twirled it around his finger, brandished it, and said, I'll wait till next time. So we've not been put on notice. The Supreme Court will very soon, in all likelihood, I could be wrong, I hope I am, pick up Kavanaugh's gun and declare what's left of the Voting Rights Act unconstitutional, probably within a year and a half. So you got to pay attention to this. Focus on this. Understand that our democracy is not only threatened by Trump 2.0 and what he's doing to have creeping autocracy, but his enablers at the Supreme Court that have been in a long project to ensure, to perpetuate their own power against those who seek a more multiracial, just, and democracy in this country, as was envisioned by our second founding at Reconstruction. Pay attention. Be aware. This is what's happening. Speak out. And keep watching us at Legal AF. I'm Mike Sachs with Court Accountability Action. Hit that subscribe button.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.